how does the Supreme Court of India, the Indian judiciary, approach the idea of justice in its various judgments in the last 92 some years, and look at it critically. And of course, when I discuss the Constitution, I will also, in light of the discussion of justice, will also reflect on what is the constitutional vision of justice. What is there an idea of justice in the Constitution? We will contrast that with the judiciary's approach to justice, and I don't want to give away the game, the plot of this talk, and tell you whether I will say that the judiciary reflects the constitutional vision of justice or it does not. But hopefully we'll discuss that also. And then in conclusion, we'll discuss the way forward. So this is what I've planned for you, 3 or 4 parts, and I've lots of case references and all that, and I hope I will not, I will be able to restrain myself from repeating all that and boring you. But first, let's turn to what is the idea of justice. And we have a conventional idea of justice, which you will learn in jurisprudence. Do you have jurisprudence as a mandatory course? Yes. It's a very, very important course. You will study in, how many of you have already done jurisprudence? Can any one of you tell me what is the idea of justice that you remember from jurisprudence? Anyone? No right or wrong answer, just to let. No one will see who spoke. It's too late. Someone could have spoken before the lights came back on. Okay. Anyone wants to try? What is your It doesn't have to be based on anything you've learned. What do you think is justice? Anyone? Yes, sir.
So treating the people impartially.
Sorry?
Treating the people impartially.
Okay, excellent. Yeah. So actually, from an academic point of view, it's very interesting that this most important concept, we'll come to it when we look at the Constitution, most fundamental concept, the first objective of the Republic, one of the oldest concepts in the world, in whichever language, does not still have a clear consensus on what it means. And many people have taken different approaches. And in particular, say in 1863, John Stuart Mill wrote a book, a famous book in which it's called Utilitarianism. And in that, there's a chapter 5 on the connection between justice and utility. And he discusses, it's actually a very short but very good chapter, if those of you are interested to read it. Mill says at the outset, one of the strongest obstacles to the doctrine of utility of happiness, let us pursue what is useful, let us pursue happiness of people. The strongest objection to that, for example, I read now where the government has said 94 lakhs of trees are to be cut in Andaman Nicobar Islands to increase development and growth and production and all that. So that's utilitarianism, right? That's use it to produce something from removing all those trees and increasing consumer happiness and so on. The biggest obstacle to all of this, John Stuart Mill says, is drawn from the idea of justice. So people will say, no, it's not justice to destroy such a large area of forests in Andaman Nicobar people dependent on it, natural resources, the ecosystem. So that's unjust, something wrong about it. So he says there is a powerful sentiment in the perception that the word justice recalls with the rapidity and certainty resembling an instinct. So even if you take a 3-year-old child and you give a small piece of chocolate to that child and a big piece of chocolate to another child, even animals, dogs, and so on, pet animals and other animals, they react almost instinctively to a sense of fairness and partiality, as you said. So the question is it something instinctual? Does it have an existence in nature? Or is it simply a concept that is artificially created, the sense of justice and injustice, fairness and impartiality, and so on? So what Mill does in this book is to find a definition of justice, he decides to look at various phenomena, modes of action, and arrangements of human affairs, which are classed by universal or widely spread opinion as either just or unjust. He sets out 5 modes of actions and arrangements of human affairs, which are classed universally, he says, or at least widely, as unjust. This includes, he says, first, to deprive anyone of his personal liberty, his property, or anything that which belongs to him by law. If the law deprives him of your liberty, your property, or anything that belongs to you, think it's unjust. So he's first listing 5 things, because then he's trying to see, can I extract some common pattern from this of the idea of justice? If I look at what people consider unjust, that's one way of defining justice. Look at what people consider unjust. Look at what people consider just, and see what is common in that. So he's first says this is something that most everyone considers unjust. Second, he says taking or withholding from any person that which to which he feels he or she has the moral right. I sit here, I make something hours of effort, and then you come and take it away. So most people will say, no, that's not fair. That's not just, that's unjust. Third, to break your promise, to break your commitment, to break faith, which is either expressed or implied, disappoint expectations, to basically betray your commitment to people. That's considered to be wrong and unjust. Fourth, here Mill says what was just said. The partiality is seen as unjust. To show favor or preference to one person over another in matters to which favor and preference do not properly apply. So you were, picking up what John Stuart Mill thought of as well in defining justice. So Mill sets out 2 modes of action and arrangements which are classed by universally or widely spread out opinion as just, not as unjust. He argues that it is universally considered just that each person should obtain that, whether good or evil, which he deserves or she deserves. And it is unjust that he should obtain a good or be made to undergo an evil which he does not deserve. So there is some concept of deserving. Speaking in a general way, a person is understood to deserve good if he does right, evil if he does wrong. And in a more particular sense, to deserve good from those to whom he does or has done good, and evil from those to whom he does or has done evil. The precept of returning good for evil has never been regarded as justice, but simply as a concession, where the claim is waived in obedience to other considerations. So if you do something harmful to me, I do something nice to you, that is not seen as my doing justice, but my being charitable or kind or considerate. Right? Mill says, but making sure everyone has their claim, has their view, is perhaps the clearest, the most emphatic form in which the idea of justice is conceived by the general mind. And this dates back to the Justinian Code and the Romans, where they said, and to the Greeks, where they basically said that justice means giving each person what is due to that person. So this element of it, although Mill identified various other additional elements. In one of our judgments, Imtiaz Ahmed, I think it was Justice Ganguly, who quotes Dean Roscoe Pound, who's a former dean of the Harvard Law School, who talked about various stages through which the idea of justice has evolved. At the first stage, Roscoe Pound says, justice was equated with dispute settlement. This is quoted in the Supreme Court judgment, Imtiaz Ahmed versus State of UP, 2012. At the first stage, justice was equated with dispute settlement. So what we're talking about is really dispute settlement, partiality, giving me what is due to me, taking away what belongs to me. That's dispute settlement. But Roscoe Pound says that the second stage, justice was equated with maintenance of harmony and order. Not simply settling disputes, but in a sense by preventing disputes, by maintaining harmony and order so that there are no disputes. And in the third stage, Roscoe Pound says justice was equated with individual freedom. So not enough not to take something away from me, not enough to give me what is due to me, but there is, as Martin Luther King said, where there is no justice, there is no freedom, there is no justice. Martin Luther King said. So this was the third stage, justice being equated with individual freedom. Pound argued that a fourth stage had developed in society, but had not yet been fully reflected in the courts. And this is the heart of what I want to talk about today. That this fourth stage has not been reflected in the courts adequately, only very partially. And that was what Pound called social justice. That is the ideal form of justice where the needs of the people are satisfied apart from ensuring they get what they deserve. Nothing is taken away from them. Their claims are satisfied. There's no partiality. They have freedom. But on top of all that, satisfying the needs of people who may not have the capacity to satisfy those needs. That is justice, the fourth stage of justice. This is actually, these four stages are reflected also in the Constitution, in the Constitution mechanism. And the fourth stage came about in our Constitution. We'll talk about the Constitution in a bit. Because it was the first time, to my knowledge, in human history, that a person from the very bottom of society, marginalized, untouchable, had been the primary author of the charter of a nation. We've had slaves become kings, we've had all kinds of things, we've had middle class people sort of write constitutions, but someone who had experienced the worst form of marginalization and humiliation, being given the opportunity by who? Not by any leaders of the party, but he was one of the members of the drafting committee, all of who were very distinguished people. They unanimously selected him as their chairman. Because he was towering intellect. They realized there was no one else. The entire Constituent Assembly who had the erudition and the knowledge and the scholarship and the wit of heart and mind that Baba Sahib Ambedkar had to create a polity for a new country for 1/6 of humanity. So he brought us to this fourth stage, envisioning justice and satisfying the needs of people, the marginalized sections. So that still doesn't, I can't say this to your 5-year-old sibling. fall asleep or run out of the room. So I need to find a simpler way for us to explain, to understand and explain what is justice. Now, all of these definitions of justice have to do with one common thread, which Mill also identifies, and where he distinguishes justice and morality. He says, where justice, something becomes justice when there is a consequence for doing injustice. Morality is also normative, but there is no consequence when you don't, you slam the door in someone's face. There's no consequence. So what Mill says is that justice is that type of action where if you breach that standard, there is a consequence. An authorized consequence, legally authorized consequence. That is justice. So they said that is justice. That action and its consequence together constitute justice. And I feel that is why, okay, there is a tension, as I said, which Miller's author has talked about, between people wanting to do whatever they believe is good for society and the idea of justice on, especially the fourth stage justice on behalf of those who are marginalized or those from whom something has to be taken away for me to have a new highway. So there's a tension there. And whereas justice was initially used to justify power, saying, yes, I want to take all this away from you because that is justice, because I am divinely made thing, I can take this away from you. That is justice. I decide what is justice. That shifted through these four stages because of the impact of democracy. You can see that it embraced freedom, it embraced equality, it embraced social justice. This idea, it was reflected in the Ratlam municipality by Justice Krishna through a fantastic phrase he used. He said, we have to shift the center of gravity of justice towards this social justice idea. He was an amazing, he was poetic. So he saw justice, he could physically see justice, and he saw that justice's center of gravity was on the side of the powerful. And he wanted to shift the center of gravity towards the powerless. And he did that. So when we are dealing with an idea that was used to justify, in other words, provide a basis of justice for the most brutal exploitation, untouchability in our society, was considered to be not unjust. Only 100 years ago, when Baba Sahib was born, he was subject to severe untouchability. He was born more than 100 years ago, but he was alive 100 years ago. So it shifted the idea of justice, the concept of justice shifted from justifying brutality to being what it was sought to be even from the beginning, which is a way to protect the powerless. A weapon for the powerless against the powerful. So that shift took place. And it has happened in our constitution also. It's not a neutral concept. It can either be for the powerful against the powerless or for the powerless against the powerful. Justice is not a neutral concept. But by attaching it to particular kinds of actions and consequences, we have narrowed the idea of justice and allowed a bigger idea of justice to kind of get lost. That's what I want to recover in the definition of justice that I I have been talking about for some years now, which I will now state to you, and then we'll move on to the next part, which is the Constitution. I argue that justice is a standard of human conduct. It comes from the word, and this is little bit reflected in a footnote in Amartya Sen's book. Although he doesn't accept it, he goes on to make another argument, which I'll come to also. The word JUS, JUS, pronounced as use, perhaps one of the most important words that law students and lawyers must know, because it is the root of justice, is the root of judge. Does anyone know what it means, JUS? Sorry? Who is very quick with their phone, who can Google it and tell me? Basically, JUS means the right value. That's why if I say I want just half a cup of water, and I can also say to a judge, your judgment is just. I'm using the word just half a cup of water, and your decision is just. Judge, your decision is just, but just give me half a cup of water. So I'm using this word. What does it mean? Why am I using the same word, just? So use means the right norm, the right value. And half a cup is the right value for me, and your judgment meets the right norms relevant to that. So use means the right value, the right norm. And stis means it comes from stir, like stick, that which stands. So use stis means the right norms of right conduct, the norms of right standard of right conduct that stands forever. So when the Constitution says to secure to us with justice, social, economic, and political, it means that the relationship between people in this country, social, economic, and political, shall be governed by the right standards of conduct, which are set out in the Constitution. Now, by shifting this definition towards a standard of conduct, away from particular transactions like taking things away, giving things back, giving you just freedom, something else, I am able to question whether the state standard of conduct, the standard of conduct of the powerful, is right or wrong, and if so, by what norm. Because by shifting this, narrowing the definition of justice, creating legal exceptions to liability, the state is able to get away with egregious conduct. And the state is able to, so Mill recognizes this a long time ago. He says, the difficulty with this approach, he says, is that each person maintains, for example, equality is the dictate of justice, except when he thinks that expediency requires inequality. The justice of giving equal protection to the rights of all is maintained by those who support the most outrageous inequality in rights themselves. Even in slave countries, he said in 1863, it is theoretically admitted that the rights of the slave, such as they are, ought to be as sacred as those of the master, and that a tribunal which fails to enforce them with equal strictness is wanting in justice, while at the same time, institutions which leave to the slave scarcely any rights to enforce are not deemed unjust because they are not deemed inexpedient. Those who think that utility requires distinctions of rank do not consider it unjust that riches and social privileges should be unequally dispensed. But those who think this inequality inexpedient think it unjust. Whoever thinks that government is necessary sees no injustice in as much inequality as is constituted by giving to the magistrate powers not granted to other people. So this narrowing of the idea of justice has enabled the state to create huge exceptions in the interest because of the tension between utilitarianism and pursuit of happiness on one hand, and the idea of justice on the other hand. So then what is that idea of justice that is pushing against this, is being pushed back through this narrowing? You will get that if you say it is a standard of human conduct. And what is that standard of human conduct? That varies from one country to another, one constitution to another, one person to the other. But in our constitution, ultimately it consists of the values that are set out in the Indian Constitution's preamble, which includes liberty, equality, fraternity, dignity, socialism, secularism, republicanism, democracy. These represent actually standards of conduct about how human beings treat each other. Equality is simply a way in which people treat each other. Liberty comes from the way people treat each other. Dignity is about how people treat each other. So when we focus the attention on what is the standard of conduct, then you start to wonder, how can, this is the dilemma I have, how can we have the death penalty given to a person who killed someone when we are also engaging in killing that person? So we say killing is not bad, just that you need a proper justification to kill. State has a justification, retribution. You kill someone, so we will kill you. But that man may think, I also have a justification. So that man will tell the state, well, you're a murderer, I'm a murderer. I don't accept your justification for murdering me. You don't accept my justification for murdering my victim. So the standard of conduct must be non-violent, that you should not kill. And it is unjust to kill. But we say killing is justice when we say the death penalty is legitimate. That means our standard of conduct, our standard of rightness and wrongness means that killing is not bad actually, just needs to be justified. Is that acceptable to us? So if a 5-year-old asks me what is the meaning of justice, I say, I have done this. It is about what is right and what is wrong, how you should behave, how people should behave to you and how people should behave to others. And what do lawyers and judges do? They promote, according to Article 39A, they promote right conduct. So that there will be less conflict in society, there will be more harmony, more peace, more well-being. And ultimately, every case and every rule and every law is about promoting some right conduct. That will ensure the protection of these values of freedom, liberty, equality, dignity, fraternity. All of us would like to enjoy those values. We may not want others to have it. We are convinced that others don't deserve to have it, but no one thinks that we shouldn't have it. So everyone should have it. So we can explain what is justice to a very small child by saying that justice tells you how to behave to others and how others should behave to you. That's a word that tells you what is the right way to behave. And what do? We promote the right way of people behaving to each other. And what is that right way for us as a society, for all of us diverse people to live together from different religions and different backgrounds and cultures? It is the 4 or 5 values that we should respect other people's dignity, their equality. What does equality mean? Equality is, a lot of people say there's no such thing as equality because we are all different. Of course, we are all different. That's why there is need for equality, because equality means that we count this, we are counted the same way. Our value for counting purposes, for giving us weightage for counting. Is your view more important than the view of the person sitting next to you? One may be male, one may be female. Yes, it's equally important. How we count your value. Why? Because there are differences. So we have to make sure we count everyone's value the same way. The weightage is the same. Your feelings, your aspirations, your dreams, your demands, your needs should count exactly the same way as someone who is very wealthy, privileged, highly educated male person. Even if you are an uneducated, illiterate, tribal woman, your aspirations, your views, your point of view should matter as much in society as that of the most powerful. Actually, that's what I mean by the constitutional vision of justice. A standard of human conduct derived from the preamble. Derived from the Constitution, consciously. That brings me to the question, what is the Constitution? And then we go to how the courts have dealt with this. We are now at, I think, 11:30, 10:30. About 45 minutes, that's much too long, I think. Sorry. We'll not take, then can we have some interaction also at the end of this? If you have any questions. But what is the Constitution? So we must read the word Constitution of India, understanding the word Constitution as a present continuous word. The process of constituting India, ongoing process of constituting India, the never-ending process of constituting and maintaining India, the Constitution of India. The constitution of a committee means what? The dean is busy in the constitution of a committee means he's busy creating the committee. So Constitution of India means it's the process by which a nation is being constituted and maintained. It's a process of creation. But that creation involves a lot of issues, struggles, competing interests, hard choices having to be made, rectification of iniquities. Now, the Constitution is a site of struggle for resolving these conflicts and difficulties. So I see the Constitution as a site of struggle. Rather than fight violently on the street, it creates forums, it creates jurisdictions, it creates institutions where you can take these issues and rules through which you can have these conflicts resolved. So it's a site of struggle that gives everyone in this country some tools and weapons to engage in the struggle. It's up to us to use those weapons to engage in that struggle. So when I talk to constitutional law students, I always tell them, according to me, the purpose of constitutional law is not simply to study decisions of courts or learn by heart the text of the Constitution. We all have diverse views, different beliefs, different faiths, different perspectives, different ideologies. That's the nature of human beings. We have our own brain, each of us, our own cognitive process. So we have different perspectives. But given that, the challenge for us as students of constitutional law, our responsibility is to develop the best craft the best legal argument that will advance our ideological perspective. Because that is the weapon through which you fight in a constitutional democracy, legal arguments. And this has to be crafted. So the law school, the court, and laboratory workshops where legal arguments are crafted. And you're living, fortunately for you, in a very tumultuous time when the constitution is being completely sort of rethought in many ways and altered. And your responsibility is not to observe it, but to take an ideological position, whatever it may be, on what should India be, and then not go out and lynch someone to make that happen, but to sit in your classroom, sit at home, learn the law, and in a legally rigorous way, based on precedent, based on established, unwritten rules of constitutional interpretation, conventions of constitutional interpretation. Craft the arguments that will result in an India of your dreams. That's what Mr. Katarki does over a very most precious resource of the world, water. He helps one party to craft a legal argument that he gets them more water. So they can send him the troops, the goons, to capture the water. What prevents them from doing that? Mr. Katarki prevents them from doing that. So he's saying, look, yes, you want the water, I'll get it for you, but I will sit here with my knowledge and scholarship, and I will craft an argument that will get you the water. So our responsibility, we must understand the Constitution is a political document. It reflects several streams of ideologies. And our responsibility is to identify what is our own vision of this country, and to use the opportunity to study constitutional law to craft the argument that will produce the India of your dreams. Similarly, we should craft the idea of justice and the constitutional vision of justice to establish the India of our dreams. That's what I'm doing. I'm crafting an interpretation of the idea of justice as a standard of human conduct that will help the powerless to achieve equality with the powerless and have a say in the running of the country, to be represented in the halls of power. An idea of justice that will be helpful for this transformation to happen, for India to move from a hierarchical society to a more egalitarian society, where no one is the ruler, no one is ruled. We are in a democracy. Democracy comes from two words, demos and kratos. Demos means common people, kratos means power. If you believe that India should be a monarchy or an authoritarian dictatorship, then you should craft an idea of justice, craft a legal argument, an interpretation that will help you achieve that goal. Then I have to sit and find a way to overcome that argument. You then have to overcome my argument.
Okay.
That's what we are here to study. Last part. The judiciary's approach to the constitutional vision of justice. First, just 2 or 3 points for lack of time. One point I want to say, I've studied this a lot. Lots of judgments talk about concept of justice, definition of justice, lots of judgments. So all over the map. There is no clear consensus emerging from the Supreme Court on what is the meaning of the idea of justice. There are a few judgments that go back to the Justinian view that it is each person getting their view. And that seems to be sort of a very safe harbor understanding of justice that they proclaim. But frankly, the Supreme Court over all these years the judiciary has yet to evolve a clear, workable, operational idea of justice, overarching idea of justice. For example, that it is a standard of human conduct, and whatever violates that constitutional standard of human conduct, equality, liberty, fraternity, dignity, is unjust. That could be an overarching view. That is my overarching view. They have not accepted that. Instead, they have developed what I call discrete regimes of justice. Discrete regimes of justice. So they have developed a definition saying Vishaka for sexual harassment. They have developed definitions for workers' rights. They have developed definitions for environmental protection. Always stopping short of having a consensus on, because there is no consensus on an overarching idea of justice. So they're operating in these what I call discrete regimes of justice, micro regimes of justice, where you get more clarity. So, for example, Vishaka is a very good example. There has been much more there is much more clarity today about what constitutes sexual harassment in the workplace. And I've seen in my own experience working in several institutions, including at Law School Bangalore, where we introduced these Vishaka guidelines prepared by the students. I take absolutely no credit for it, but during my time, we established it. We saw a very positive change in the behavior of students. And because there's more clarity about what is right and wrong, what is just. Remember, justice is morality with a stick. So the moment you said this morality and immorality now is lifted into an illegality and injustice, serious illegality, not procedural illegality, but a serious illegality, we managed to bring about change. So in these now, where the attempt has failed is prison reforms, police reforms. Justice Krishna Iyer had made a tremendous effort in his prison jurisprudence to bring about some change, but that has failed. We've also failed to bring about greater clarity about social justice, which was the main contribution of Baba Sahib Ambedkar, where he gave tremendous clarity. There was absolutely no reason why we could not have gone forward. For example, about reservation, right? He was very clear that this is not what he wants is not reservation, but representation of all communities in the judiciary, executive, and the legislature. Reservation is only a tool. But representation is a distant dream. And reservation is completely attacked and undermined, although nobody's interested in reservation. They want representation, but you're getting neither reservation nor representation. Women's rights, very little progress on the ground on gender equality. Right? We still don't have a civil right to equality in this country. We only have Article 14, which is a prohibition against the state shall provide equal protection and equality before the law, but we don't have a civil right, statutory civil right to equality, which we need, a general civil right to equality, which many other countries have. Many of us have been pressing for that. The agency not getting it. The judiciary has tried to read 14 in such a way as to expand that and create such a right, but it's still inadequate. So the idea of justice is kind of been confined and cabined into small areas, the large constitutional idea of justice, outright denied in many areas. by the judiciary and the legislature, and still remains a distant aspiration for most people. What's the way forward? I think the way forward is for us to continue the struggle for justice by demanding that clear, measurable, operational standards of conduct reflecting these core constitutional values of equality, fraternity, dignity, liberty, are operationalized like we did in Vishaka, are operationalized at the micro level and implemented so that it's very clear what constitutes injustice is a violation of these constitutional principles at any level, anywhere. And to strengthen the way in which we interpret and understand the idea of justice so that justice becomes actually a living reality for the people of this country in terms of the preamble of the Constitution. Let me stop here. It's gone on for nearly 1 hour. It is much more than I intended. I'm sorry. Let me stop here. 4 minutes short of 1 hour. Can I stop here and then ask if you have any questions or comments? Yes. With your permission, sir. Yes. Yes, please. Yes, sir.
It is not a neutral concept.
Correct.
Could you please elaborate on that?
Yes, certainly.
Because what we study is like is not free. It is the neutral concept because all the both the parties in the dispute agree with that. So that I understand that it's a neutral concept.
Yes. Very good question. Thank you very much. See, I am saying you can take a view that justice is the result of a process. It's a decision, the outcome of a process. Who wins, who loses. That is one way in which commonly justice is understood. And that is keeping things at that first stage in the 4 stages that Roscoe Pound discussed. It's at the first stage. It's about giving something, taking something away, right? Through a lawsuit or something else. And there we could say that it's at the dispute settlement level, that first stage. There you could say that the way in which you could argue, although I will not accept it, that you can make sort of neutral arguments that will resolve the dispute. But frankly, even those arguments are not neutral because they involve valuation. What is more important, what is less important, which argument should be taken up, which should not be taken up. There's a process of valuation that comes into every decision, and that's why somebody loses and somebody wins, right? So so to say that law is neutral or the process is not neutral or the outcome is neutral, I think is not really accepted any longer anywhere. I think no one. That's a myth that is quite outdated now. That it's neutral because somebody, let's say, this is a famous example. If somebody, there are two children who want to play the violin, and one person owns the violin, the other person can play it very well, but does not own it, wants to play it. How do you settle that dispute in a neutral way? So somebody says, this is my property, so I want to decide and I will play it. Somebody says, this is a violin. I want to play it. I know how to play it. So which value will you give greater weightage to? That is, it is that process of what is right. So we have to decide if the right conduct, the right value is ownership is important. Property is important. Not the functionality, but the property ownership is important. So that becomes, so justice, the youth in the justice becomes property is important. So it's property oriented idea of justice. We'll say, okay, sorry, you may know how to play it. Let's say this person does not know how to play it and doesn't want to play it and doesn't want anyone to play it. It just wants it to be kept there. It's mine. Nobody will play it. So if I take a property oriented approach, then you'll say, yeah, it's a fair outcome. The person is the owner. She doesn't want you to want anyone to play it. We have to accept that. But it's not neutral. Because the other person is saying, yeah, it's not my own, but it's lying there, nobody's using it, I want to play it. So use is the word justice. I realized I've been working on it for 2 decades now. The word, I realized 2 years ago, is an empty word. It's a question of what you pour into that word. It's an inherently empty word. So what Hitler does is justice according to him, but not according to the Jews he killed. So how do we give content to so it says use means right value. Justice is a standard of conduct that prescribes the right values. But who gets to prescribe it? When you say you must get what you deserve, who decides what you deserve? On what basis? So if the norm to decide what you deserve is to each according to his or her need, from each according to his or her ability, then you get what you need according to what you need. But if you give a just desserts approach, you say, okay, you will get what you have contributed. I've worked so much, I've contributed so much, I've contributed to this, now give me the fruit, the dessert of that work. So at every point of time, we are defining justice, giving it content based on our values. That's the result is you have patriarchy, you have caste supremacy, you have majoritarianism, because we are giving greater value to what we want to give greater value to. So how do we contain that process of interpreting justice? By bringing in these 4 core values, which will become a limit on how you can attribute, how you can give content to justice. What are those? Freedom. So I have to accept that this, there has to be freedom, right? Not property, but freedom. So the person wants to use. So actually, there is a Supreme Court judgment that basically suggests that if I can do something without taking away something from the other person, then the law should weigh in favor of letting me do that. So if you're not playing the violin and this person knows how to play it, there'll be no harm to it. In fact, the violin will improve the more you play it. Then I should say, no, you may be the owner, you may not want to do it, but she must have the freedom of choice to play that. Let her play it. Dignity, equality, fraternity. So these becomes constraints. These become constraints on how I attribute. We'll still attribute value. I will still think justice is what I think is right. But the Constitution is providing a fence, a constraint around it. You can want what you want. You can want what you want, whatever you wish, but you cannot take away freedom, dignity, fraternity, equality from anyone else. So we are now trying to use justice as a constraint that will, on the powerful, who have the option to take things away or to control others. That's why there is a resistance to that. That's why there's a resistance. We don't want to define justice that way. And the Constitution gives us an opportunity. Very few people in the world have the opportunity we have to define justice using the Constitution in a way that will actually bring about more egalitarian positive change in our society and give dignity and freedom and liberty and dignity and fraternity to vast masses of people. So yeah, so that's what I mean by saying, there's no neutrality in justice. Justice always has some priority, some value that is more important than others. We have to constrain that idea of justice because justice comes from my own feeling about what I want and what's more important to me. And if I'm powerful, it becomes dangerous to others. If I'm powerless, it's okay, there's no consequence. So the more powerful I am, the more constrained there must be on my ability to define justice. Thank you for a very nice question. Yes, sir. Yes, please.
So as there is a statement, justice delayed is justice denied. Once, if any injustice has been taken place to a category of people or to a person, and the justice which is rendered to him, it takes to a particular extent of 20 years, 30 years. Whether the sanity or the validity of that judgment would not be satisfied or would not be benefit for those particular people, or it will be benefit for the next generation. So whether the sanity would get disturbed for the lengthy period or extent it takes for a order.
Thank you again for a very good question. Let's go back to Roscoe Pound's framework of 4 stages, right? So you're using justice in that first stage of dispute settlement. You're saying it's taking long to have dispute settlement, right? But I'm suggesting there's another way of looking at justice, which is a standard of human conduct, the values of the Constitution. Are they being damaged or not? And in some cases, many cases, most cases, if the case is decided fast, if the case is brought by someone to protect constitutional values, then delay will affect the prevalence of those constitutional values. It will take away freedom, it will take away dignity, fraternity, and so on, equality. Right? Delay generally is bad. But in our country, what happens is that there is very fast justice in some cases, and very slow justice in other cases. That's what we have to think about. Prashant Bhushan goes from tweeting, or now it's called Xing, or whatever, tweeting, to being finally convicted by the highest court in the country in something like 2 weeks. Nowhere else in the world can you do this, such speed. So there is a selective speed. You're pressing on the accelerator when you want to, and you're simply forgetting to move the car from the gear from neutral in many other cases. You're stuck in neutral. So there is this is the result of the fact that ultimately the Baba Sahib had warned that when the British leave, India will be ruled by an aristocracy and an oligarchy. In 1930, he told the first roundtable conference. Why? Because what is an oligarchy? Oligos means few. Monarchy means one person's rule. Oligarchy means the rule of a few people. So he said an aristocracy and an oligarchy will rule India. Why? Because there were 3 very powerful forces in India before independence. One was the British, who were then ruling. The other were Muslim rulers who had ruled, and the Muslim elite who had ruled. And the third was the Hindu powerful elite, the Hindu elite, so-called Hindu elite. And 2 of these forces left. And since 47, there is no group in this country that has the power to challenge the Hindu elite. That's what he meant by an aristocracy and an oligarchy. So when the oligarchy wants things to move, they move with jet speed. When they're not interested, they're languishing. So I have been working on creating performance standards for the judicial system. I had the opportunity to be to propose, and Justice Kapadia created and then made me the first chairman of the National Court Management System Committee. And the idea was we want performance standards. This is one of the few countries in the world where there are no monitored performance standards. In many Western countries, there are 200, 250 performance indicators that are constantly monitored. For the court, court is an institution, not a judge. Court is a court is an activity carried out in accordance with certain rules by a number of people. Judge alone cannot run a court. So we need performance standards. We don't have that. We need to measure those standards. We need to deliver those standards. So we have made a beginning. That committee has created a set of model guidelines and performance standards on various aspects and put it on the Supreme Court website, and encouraging judges and courts to adopt them. There are no standards on quality. How do you know what a judgment is good or bad? No standards on quality. Many other countries are measuring quality. It's not easy to measure quality. It's a public good, but still there are ways of measuring it in a limited way. We're not doing that. We still don't have a set of measurable, precise specifications on what kind of, I use the word QASK, qualities, attitudes, skills, and knowledge, are required to be a judge from the Supreme Court down. Simply because you're a very good lawyer doesn't necessarily mean you'll be a very good judge. Mr. Katati knows much more than me about that. It's like saying simply because you're a very good flight engineer doesn't mean you'll be a very good pilot. So we don't have any standards that others have and we need. Right? We have a lot of infrastructure and a lot of monitoring. So there's a lot of reasons why this delay happened. So our idea is, yes, the delay, we must complete the processing of the cases in a reasonable time. There's a shortage of judges, but there is no docket explosion. There is docket exclusion in this country. We have one of the lowest rates of new cases filed per 1,000 population anywhere in the world, especially in states where literacy rates are low and education is low and there's more poverty. In the north, for example, as against the south, the rate of filing of new cases per 1,000 population is very low. It's like 4 or 5 cases in Jharkhand, Bihar, 40 or 50 roughly in Kerala and Delhi and so on, as against 100 in Singapore, 200, 250 in Europe, and around over 300 in the United States of new cases filed per 1,000 population. One test of a democracy is, are people going to court to protect their rights? It's not as if rights are more violated in Kerala than in Jharkhand or Bihar. I would say it's the opposite. I've lived in Madhya Pradesh for 5 years, and I can tell you certainly Madhya Pradesh also has a very low rate. But they will go to court in Kerala if you misbehave. They go to court, and they hold the courts accountable. I was once in the Judicial Academy. I was visiting. I won't name a state, but some state where there was less accountability, and I was going back to the guest house in a car which was marked High Court car. So I stopped to buy some fruits, and the guy wouldn't take money from me. So I had to deal with that. We have come in this car. It's not a car that judges travel, staff travel, or the judges' car, but still they were probably more afraid of the staff than of the judges. But then I had to insist, and I paid the money. So I said the story to some Kerala judges, and one of the judges told me, let me tell you the opposite story. I was coming in my judge's car, district judge's car, going back home. I stopped in a shop to buy something to take home. I came and I gave this to the guy to pay, And he asked me, you came from that car, are you the judge? He said, okay, this is, and the numbers are, I don't remember. This costs 100 rupees, but for you, it's 120 rupees. So the judge asked why. He said, because I have a case in your court for many years, not being resolved. So I'm going to fine you. So that's a level of interest and accountability, right? And of course, the judges were happy. They're happy to work in such an environment where there is pressure and accountability because it produces better quality judging. So it's a complex issue. But the issue I want to focus on today is how do we put a content into the idea, deliberately put a content into the empty idea of justice that will help bring about a transformation of this country that and make it more egalitarian along the lines of Baba Sahib Ambedkar's vision in the Constitution. To realize equality, fraternity, dignity, and liberty. You know, and that's something that we can do in the legal academy. We can do. We can start to give content to the idea of justice consciously. So I said the job of those who, in fact, I said some people I work on political law. Constitutional law should actually be retained political law and combined with administrative law, because a lot of courts, what they do in the name of constitutional law is really administrative law. But this is political law. And political law is highly ideological. And there's nothing wrong with that in a democracy. You have your ideology. The US, they appoint Supreme Court judges based on their ideology, not hiding it. But then they have to craft legally rigorous judgments once they get on that bench. They can't just say, you know, I rule in favor of the Republicans or the Democrats. They have to come up with good legally crafted arguments that will take forward their ideology. That's what we can do in the academy. And let's have all ideologies represented. Let's have, you know, because we'll all benefit from that rigorous, diverse thinking. Justice is, the idea of justice is an idea that I think we should give a lot of importance to in legal education, and have exercises about how we can imagine justice from a legal point of view in different ways, and why we would do that, and explain, you know, why would I want to imagine justice in a particular area. I want to give a constitutional vision to justice because I know that constitution is favored, is structured in favor of the powerless. And therefore, I want to give it a constitution vision. But if the constitution is altered, I'll have to come back with another argument about the idea of justice. Thank you again for yes. Please tell me to, please, sir, please stop me whenever you want to, because I can go on like this for a long time. So don't hesitate to stop me.
Sir, as you mentioned earlier, that the meaning of the justice has been narrowed down by attributing it to the particular aspect, which has resulted in the escaping of the state from the liability. So how the state is escaping from the liability merely because we are narrowed down the meaning of the justice?
Because, see, ultimately, that's where the legal argument comes in. So where is the legal? The legal argument focuses on what is the standard of conduct we are upholding here. Actually, it becomes difficult to uphold the death sentence because you have to answer that question. What is the standard of conduct? You are saying killing is legitimate. You have to be honest about it. There are people and countries where they will say killing is legitimate. They believe in killing. But we can't say, you know, ahimsa paramo dharma, and then say killing is legitimate. Right? So they are doing it by interpretation. The whole game in law is interpretation. Interpretation that is sound and valid, legally valid, not just what you feel like, but has based on legal reasoning, based on these unwritten conventions on interpretation, meet all those standards. If you can come up with solid interpretations, that's what they've done. They've just narrowed the scope and ambit of justice. And so the reaction of those who want, for example, Justice U.C. Banerjee has written a number of interesting judgments, trying to expand the concept of justice in many ways. You know, he is one of those who is really focused on that. So some of the judges have, Justice Krishna has done that, Justice Bhagwati has done that. So, Justice Kinappa Reddy, Justice Desai, A. Desai, number of these judges have tried to widen the concept. But by applying it at least, like Justice J.S. Verma wrote this judgment on Vishakha. So he created a discrete regime, what I call a discrete regime of justice where women would be protected in the workplace. So some of these people are, the judiciary is trying to create some more space for a more progressive idea of justice, more egalitarian idea of justice. But the academy is neglecting it. You should realize that your responsibility and your fantastic opportunity as students of law is to craft rigorous legal arguments that will advance India towards the India of your dreams. That's what you should do. Whatever your ideology may be. I'm a Democrat. I don't believe that there should be only my ideology. I believe that everyone should have their perspective. But let's do it let's play the game according to a set of rules. In a peaceful and constructive, intelligent, creative way. So I think, yeah, that's how they do it. They've come up with interpretations that there are 4 stages. We are not really, we are still stuck in first stage of dispute settlement. Our idea of justice is still very much in first stage of dispute settlement. We have not even gone to stage 3 of freedom, let alone social justice. And this has been recognized in a judgment, but not that there's been no progress, but these 4 stages have been recognized by Justice Ganguly in a judgment in India's amendment. Because he wanted people to know and reflect on this. So, but the academy, students and teachers should really excellent questions. I'm really deeply interested. You've got a fantastic set of students here. I want you to give a round of applause to yourselves. Yes, sir. Yes. I can't, because of the light, I can't see properly who's asking. Yeah. That's okay, no problem.
So, when a dispute involves multiple constitutional rights, and the Supreme Court has expressed its views pertaining to those rights, separate jurisprudence or set of history of justice, and those multiple rights are in conflict with each other, sir. And they don't necessarily fall in the discrete regime of justice as you expressed. Then, what should be the right way for the administration of justice, sticking to the constitutional value or the PSW?
See, ultimately, the Constitution creates the Republic of India and all its institutions. So everything has to be guided by constitutional values. And idea of justice must also be guided by constitutional values. But in every case, there are multiple ways in which you can interpret this hard and fast, the hard and fast impression that you get from reading judgments is wrong. I mean, I've actually learned a huge amount after I've started in a very few cases, selected cases, arguing in the Supreme Court, because I suddenly realized that the court only takes into account a very small slice of what is argued. And they present it as a complete and comprehensive and neat set of arguments and decisions, but it's not the case. And I argued the EWS case. I challenged EWS, the constitutionality, and I argued the EWS case. And during that time, I was talking to Mr. Katarthi a lot also. He helped me a lot, guided me a lot. And but one example I have, I can immediately springs to mind, not in isolated, I don't need to single him out. But one of the judgments, one of the majority judgments, 3 majority judgments, surprisingly, we got 2 dissents. Fantastic that we got 2 dissents. We thought we'd have in cricket terms a whitewash, 5-0 judges, but we got 2 dissents. But one of the majority judgments is employing the idea of distributive justice to justify, without explaining, why excluding a poorer person and giving to a better off person reservation is distributed justice? Simply because the poorer person who is entitled to, eligible to, but does not get any reservation, was born into a quote unquote lower caste. Okay, say that's fine. So you say, find a justification for it. But distributed justice is to take from who has more and give to those who have less. But in the judgment, one of the majority judgments justifies this as distributed justice. Now, that is, maybe they couldn't think of any other argument, but that argument was not actually argued in court at all, to my knowledge. I sat almost through the entire proceeding. So I don't think, and I would request Mr. Kataki to speak to this question. You have far more experience than me, but I'm not sure that these tight black and white issues are so common. Generally, there's much room for interpretation and to bring in contribution values. Would you like to add anything to that? I think after when you speak, yes. Sorry, Mr. Katak is here to speak. I'm eating into his time. Maybe you just have one or two more questions.
So, one question.
Yes.
How can I have a balance between the moral and legal? Something might be morally wrong, but it may be legally right. And how can we have balance between
Ultimately, law is concerned with only one question. One question. That's a moral question. The whole discipline of law. Is human conduct right or wrong? And if it's wrong, what are the consequences? So that's something you can tell a 5-year-old if you're not a judge with any justice in front of you. What do you do for a living? I try to ensure that human conduct is right and not wrong. Now, what is law? Law is a hypothetical fact pattern intended to prevent wrong conduct. Justice is the standard of highest standard of right conduct, on the basis of which we say this conduct is right, this conduct is wrong, and we prescribe a hypothetical fact pattern saying you shall not do this. Take murder. It's a hypothetical fact pattern. You have done an act with the intention to kill, and as a result of that act, somebody dies. That is how murder is defined, right? That's a hypothetical fact pattern. If the actual fact pattern matches that based on evidence, then you get a conviction. So law is only an instrument. So this of justice. So there are a lot of tensions created in these judgments between natural justice, between justice and law. The idea is that justice constrains law, but now we see that law constrains justice. There is another judgment by Justice Sakashivam which basically says that you should only decide according to law, and if you do it properly, then it is justice. But that is, in my great respect, he's a great judge who has written very good judgments and he's a very scholarly judge, and so I have huge respect for him. But with respect, what I feel is that the standard of conduct, that is, if you define justice as a standard of conduct, the standard of conduct, if law is concerned only with right or wrong human conduct, then the standard of conduct that is what we call justice must be the highest, most controlling norm. And then the hypothetical fact pattern must be interpreted so as to protect that standard of conduct. So that cannot be a conflict between law and justice. You have to interpret the hypothetical fact pattern to prevent the wrong conduct as defined in the idea of justice. And now, so justice is a moral standard, but as the Mill says, John Stuart Mill says, the difference between morality, morality is also about right and wrong conduct, but the source of morality is different. The acquisition of legitimacy or legality of morality is different than justice. So justice is the highest set of norms that constitute a polity. That's why they say eternal norms, eternal values of right conduct. So I should button my shirt properly is not really part of justice. That's, but that I should respect people is a fundamental, the dignity of people and freedom of people is a fundamental norm. So United States Declaration of Independence says life, liberty, and the pursuit of happiness. Actually, it's very interesting that they brought in the pursuit of happiness because in one of the earlier drafts they had brought in anti-slavery comments into the declaration, and that was deleted. So the pursuit of happiness was actually to recognize it was an anti-slavery statement. But suppose that is deleted and say instead of life, liberty, and the pursuit of happiness, the values are death, slavery, and the pursuit of sorrow. The United States is no longer the United States. So it's like the basic structure of the Constitution. Justice is the basic foundation of a polity, defines what are the norms that constitute us as the republic. It's a polity. It has to inform everything. All our actions must. That's why Article 39A says the operation of the legal system shall promote justice. So everything we do must promote the eternal values that are in the preamble of human conduct. It's overriding in my view. Thank you very much for wonderful questions.
Thank you, sir, for your words of wisdom. I now request Professor Dr. Professor G.B. Patil, Dean Case, to felicitate our guest, Professor Dr. Mohan Gopal. Sri Mohan C. Patil, Senior Advocate, Supreme Court of India, guest of honor for the Endowment Letter. I request sir to kindly address the gathering.
Professor Mohan Gopal, guys, members of the faculty of law, Karnataka State Law University, students of law, and general public. It has been a great honor for me to be chief guest of a function where one of my dear scholar, Professor Mohan Gopal, has to deliver a lecture. When we thought of a person who was suitable to deliver a lecture in 2023, immediately the only one name came to my mind, that is Professor Mohan Gopal who should take this, because he has been a foremost scholar in constitutional law in 2023. He has argued in a very scholastic manner in the famous economic reservation case, although he didn't succeed, but his arguments were noted by the Supreme Court with great respect. Professor Mohan Gopal, I first time met when he was the chief guest for the Jowli Moot Court competition in 1998. I was the person who had drafted the moot problem. And thereafter I met a couple of times, and we have a very common friend, that is Indra Jaisi, and who often calls with both of us. And that's how we get educated also. The topic which Professor had chosen is so exciting that it goes to the root of the legal system. When you say justice, as you rightly explained, is standard of conduct. Justice is not something a myth, it is standard of conduct. The immediate question arises, who decides the standard of conduct? What is it? Imagine when the state was invented, we're all living in a tribal society, maybe in a natural way. The first question was how to administer, how to rule over the masses. The ruler at that time thought that justice is done if I rule with an iron hand over the people. Well, that was necessary to maintain the rule of law in that rudimentary sense. But later, the concept changes. People thought, you can't just rule like this. You are not donkeys. Professor Joseph Raj puts it very nicely. When a sovereign rules, and compares it with a chess player, in a chess, a player can keep the points where he likes. That is his freedom. But can sovereign do that? When he keeps, he orders the people. When he makes the law, he prescribes the commands. You sit here, you don't sit there, you go there, and you do that. For that, the difficulty is, unlike in a chess, where the points have no emotions, have no brain, here humans have emotions and humans have brains. So when a sovereign orders an individual passes that you do this, you shall not do that, he has to take into account the freedom of the individuals, liberty of the individuals. Am I doing it something more where the resistance will come? So depending upon that, the sovereign decides what should be the law and what should be its command. Here comes the justice. The deontological school of law, school of ethics, is the first to tell us how to order the society. The binary concept was invented, that is right, wrong. So everything has to be decided in this world based on what is right or wrong. Either it is right or it is wrong. There may be gray areas, but this binary concept invented to decide what is to be, how the world to be ruled, how the society is to be governed. But the question arises, how do you define what is right? The concept of right depends upon that is called justice. You will have to look to various values. There are various ideological questions come. What is right for me may not be right for another. The gentleman asked a question, can justice be neutral? And the professor rightly said, no, it cannot be neutral. It has an ideological orientation. At each time in a society, at each time in the governments, the governing people decide what is good, what is bad. So that is how the concept of justice is assigned at the highest level. The justice has two parts. One is justice at the institutional level, where the ruler or a sovereign decides what is good or bad for the people, and he makes laws accordingly. Then the second aspect is administration of justice, which are very concerned with, because students of law are always taught and always made to believe that justice means what is given in the court of law, that is justice. No, that is the secondary aspect of the justice. The primary aspect of the justice is the sovereign who arranges rights and responsibilities in the society, who decides based upon certain ideological ideas what is good and what is bad. Utilitarians thought that the way to decide what is good and what is bad is what is going to have the maximum happiness. The principle of maximum happiness. That is how they adopted. The various ways were all had a different thing. He said social justice. You must look to how the society gets justice. So this is how the concept developed. Initially, freedom was considered to be the only virtue of justice. You freedom of the people, that's fine. Then it changed. Freedom is not enough. You will have to have equality. Then equality came as a second concept of justice, that it's not just a freedom. People have to be treated equally. Most important, no discrimination. There cannot be unjustified discrimination. I put it. There will be discrimination always when you govern, but there cannot be unjustified discrimination. And that's how the second concept came. Then the third concept came within equality. It's not a negative equality. It is not just protecting the freedom of the people. It is not just an absence of discrimination in protecting the freedom. It is also a positive equality to be promoted. That is, the state must take steps to uplift the people who are poor, who have been suppressed and oppressed for generations together, unless these people are given a lift and put on par with the developed people, there cannot be justice. So that's how the concept of the justice in a positive form came, equality in a positive form. There is also talk nowadays that there is a justice, this is reverse discrimination. Well, people say that you have got social justice, you have done reservation, fine, but we feel there is a reverse discrimination. I don't know. Personally, I feel there is no such thing as reverse discrimination. But whoever wants to argue reverse discrimination should craft his argument, as Professor said, legally, logically, and presently. If it is convincing, certainly it might be acceptable to say. It's not that it is not. Recently, I heard in the United States of America, the affirmative action has been overruled because the court thought that the lawyers on this side have presented more logically correct argument. Whether that is ultimately acceptable to people or not is a separate question, which the state will decide. But at the moment, the court has said that it is not possible. If it is administered, it will cause a reverse discrimination. That's how it is. So we'll have to continuously evaluate the standards on which the state has to administer, the state on which to be governed. The gentleman asked the question, which Professor said I should answer. That is, what happens if there are conflict among the rights? Yes, it often happens, and I deal with that subject also. If there are a couple of rights, right to freedom of speech is there, right to association is there. If the conflict arises, how do you do about it? Right to property is there. Similarly, we have in the distribution of the water something called prioritization of the uses of water. The drinking water has the highest priority. Then comes water for the life purpose, that is irrigation. Then comes the water for the production of power. Then comes water required for navigation. So the prioritization is decided again based upon the principles of justice. What is just and what is unjust. When you give priority to the drinking water as highest, because you give it on a basis that if a person is deprived of a drinking water, he cannot survive. So it has the highest priority. First, serve drinking water to the public, and if anything left, do it for next priority, that is irrigation, because it produces the food. And if something is left, do it for production of power. If something more is left, all right, create a channel for navigation. That's how the priorities are again decided. Again, the priority is a question of justice, depending upon what is the ideological orientation of the ruler, of the sovereign, or what we now have, the parliament, a democratic institution, which really orders the elections in the society. Thank you very much. I really enjoyed what Professor taught us today. It was a wonderful class. The theoretical ideas of justice, I had never heard it. This was not taught to us in the school. Of course, we had been reading here and there, but the whole thing presented it in 2 hours in such a described and beautiful form. It was a wonderful experience, and we all hope to benefit this. And you are the next generation to get benefit this for the next 50 years on.
Professor Dr. G.P. Patil being here tell you to felicitate our guest of honor, Sri I request Dr. G.D. Patil, Dean Case to kindly give his presidential remarks.
Good afternoon to all of you. Esteemed Professor Dr. Mohan Gopal, a teacher par excellence, an erudite scholar, and an eminent administrator. Yesterday, when he reached Hooghly, we were about to plan for dinner. What Professor said is, at the age of 76, this is a lesson for all of us. And he said, no, Professor, you don't come to us because I have to prepare for the next day lecture. So even at this age, that speaks the quality of a teacher. Sir, we are very happy for taking out time and helping us in organizing this event. A former Vice Chancellor of National Law School, Bangalore, and former Director, National Judicial Academy of Supreme Court of India, and respected Sri Mohan V. Kartarki, Senior Counsel, renowned water law expert both nationally and internationally, and a standing counsel for many states, especially on water disputes, took a lot of initiative in starting this endowment lecture. I was remembering my sweet memories in 1983. Sir was our super senior. He used to tell us constitutional law. We used to meet at Uraya Hostel whenever there are difficulties. He used to sit with us and discuss for hours together the constitutional, especially the basic structure theory, Keshwananda Bharati, and all that. Srimati Madam Anuradha Vastrak, KS Registrar, Dr. Ratna Baramgoda, Registrar Evaluation and Director Law School, Madam Vijaya M. Kartarki, distinguished invitees, Major Siddhingaya Hiramet, respected members of Honorable Mr. Justice R.G. Desai, learned members of the bar and bench, members of the media, and my dear students. What Professor said, I don't want to add anything. It is not a presidential remark because I am very feeling little, what is justice here? When Professor has spoken so much about justice, the concept of justice has different dimensions. Sir has explained right from Surat Mill to Roscoe Pond and what constitution means and how the Supreme Court of India interpreted the concept of justice and had to arrive at a conclusion. So what is justice is a different, having different connotations, different meanings. So what is justice at this particular point of time is also a big difficulty for me to propose the presidential remark, but also as a matter of, the circumstance demands, I just, speak about what Madam B.V. Nagaratna, Justice Madam B.V. Nagaratna said. There is a gap between law and justice. Law is not a science. Law has to deal with ordinary human problems. You cannot solve the problems with a mathematical precision. It is not a mathematics like 2 and 2 is 4. In law, it may be something else because we have to deal with ordinary human problems. And likewise, also Justice Gawai has said while addressing the law students and Pune Law School, he said the students of law should have the basic quality of a student of law is to have empathy. Today, that is the need of the hour. What is the state of affairs of justice today? If you find out, lots and lots of docket explosion, not docket explosion, as Professor said, it is a docket exclusion. Today, the common man is going away from the, judiciary. Common man is losing faith in the judiciary. There are, 5 crore cases pending in the judiciary, right from lower court up to the higher court. And there is a lot of problems. The plight of under-trial prisoners waiting, languishing in the jail for, years together, decades together. Perhaps, yesterday I come across a case, a civil case where a man of 108 years, a Narsingh Rao from, rural Gaikwad, he filed a suit and he purchased a land when he was at 55 years of age. And in 1968, and in 1969, The original owner has hypothecated land to a bank and the bank has issued a notice. Right from 1969 till 2000, 2021 July, he was fighting in the law court, and even after 53 years, 108 years of age, he has purchased land 53 years back, but he could not, get justice even after the registered sale deed in his favor. That is the fate of the people in this country, and especially when poor people are there, they have no access to court. This is very dangerous and constitutionally guaranteed right in America. But what is in India? Right to speedy trial is one of the components of, as Justice, Krishna has also stated, our justice system, even in grave cases, this is what Krishna said. Our justice system, even in grave cases, suffer from slow motion syndrome, which is lethal to fair trial. Whatever the ultimate decision, speedy justice is the component of social justice. If speedier justice is not there, whole society will suffer. So in that context, lots and lots of responsibility is on us. Sir, whatever you have said, Constitution is fine. Constitution, the framers of the Constitution have visualized, have aspired for an egalitarian society. But how we can realize that concept, socialistic pattern of society, as it is rightly said by Ambedkar, in his last speech when Constitution was drafted. This was his last speech. He said in 25/11/1949, on 26th January, this is what I quote, on 26th January 1950, we are going to enter into a life of contradictions. This is what he said. And what we are in we are in 2023. Look at the fate of the people in this country. On the 26th January 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one vote, one value. In our social economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. How long shall we continue to live this life of contradictions? That is what he said in 1949. How long shall we continue to deny equality in our social and economic life? If we continue to deny it for a long, we will do so only by putting our political democracy in peril. That we are in danger of political democracy is in peril. We must remove this contradiction at the earliest possible moment, or else those who suffer from inequality will blow up the structure of political democracy, which this assembly has to laboriously build up. This is what he cautioned in 1949, and today we are in 2023. The fate of justice, the people are awaiting, but still justice has become a distant dream for poor people and a common man. And there are challenges. Today, if you see the poor people, though their constitutional and valuable legal rights are violated, they have no access to court. This is one. And the second most important thing is the cost of quality legal service. The cost is escalating. Poor man, cannot afford, because poverty, more than 50% of the, even after, Azadi Ka Amrut Mahotsav, 70 years of independence, still the poor man, and he cannot afford a good lawyer, an eminent lawyer. This is one aspect. And the other aspect is majority of the talented, competent law graduates, majority of them are joining towards the corporate sector. There is a dearth of lawyers at the lower court, civil and criminal court. This is the fate. And if this continues, where we are landing up, what will be the rights and liberties of the people? Because justice means what Sir has said, liberty and freedom. So today, there is a threat to life, liberty and freedom of the people. So in this context, there is a great responsibility on all of us. We have to rise up to the occasion and help people who are in need of justice. With this few, offering my observations, I take this opportunity and express my gratitude to Sir for traveling all the way from Delhi and gave a very good, highly scholarly discourse, which will go a long way in our career. Sir, we are very much grateful to you on behalf of Karnataka State University and the extend my gratitude to you. I also extend my gratitude to Mohan V. Kasarkar, sir, who has, taken the question of organizing this event. Thank you, one and all.
Thank you, sir. I now request Professor Dr. Rudna R. Dharambagar, Registrar Evaluation KSLU and Director KSLU's Law School, to kindly propose the vote of thanks.
A very good afternoon to everyone. Distinguished dignitaries, esteemed invitees, dear faculty members, and dear students. On behalf of Karnataka State Law University, it is my utmost privilege to propose the vote of thanks. This endowment lecture has been instituted by Mrs. Vijaya Kakarki in memory of her father, Honorable Justice late Shri R.G. Desai, to honor his services. Every year, eminent speakers are invited to deliver lectures on selected topics for the benefit of students and for the benefit of faculty members. Today, it's a great honor to have Professor Dr. Mohan Gopal, former Vice Chancellor, National Law School of India, University, Bangalore, and former Director, National Judicial Academy, Supreme Court of India, to deliver this year's Honorable Justice Shri R.G. Desai Endowment Lecture on the topic, The Constitutional Vision of Justice. Sir has so eloquently and fascinatingly delved into the concept of justice, analyzing its evolution since the ancient times till the present day. Professor Dr. Mohan Gopal sir has kindly accepted our invitation and has delivered a highly insightful and scholarly lecture. Sir, it's a treasure of knowledge you have shared, and it was really fascinating to listen to your lecture. And our students and faculty have been immensely benefited. On behalf of university, I express deep sense of gratitude to you, sir. On this occasion, we have Shri Mohan Kakarki, Senior Advocate, Supreme Court, as guest of honor. On behalf of university, I express profound gratitude to Shri Mohan Kakarki for gracing the occasion and for his enlightening thoughts. Thank you, sir. Professor G.V. Patel, Dean, Karnataka State Law University, is presiding over the program. I express heartfelt gratitude to Professor G.V. Patel, sir, for his valuable perspective. I express sincere gratitude to our registrar, Srimati Anuradha Vastrat, AS, for her unwavering support extended for this program. Our heartfelt gratitude to Mrs. Vijaya Kakarki and family members of Honorable Justice Shri R.G. Desai for gracing the occasion through the virtual mode. Our profound gratitude to Major Siddhalingaya Hiremat, former registrar of our university, for gracing the occasion. Thank you. Our sincere gratitude to all the esteemed invitees, press and media, dear faculty members, and dear students. Thank you.
End of